Yes. Item 2, yes. Why? Who is the senior? Huh? Okay. Okay, right. A general prayer has been made on behalf of Mr. H.R.A. Chowdhury, Learned Senior Counsel for the appellant. Who is for the other side? Ms. B. Boyan. Mrs. B. Boyan, Learned Additional PP.
Yes.
And Mr. U. Chowdhury. Appear for the informant.
We are ready with the case. I think they don't have a good case.
I don't know. Now what to do? Okay. Huh? On the prayer made on behalf of the Learned Senior Counsel, someone who is apparently having some personal difficulty. This is the matter after review.
I recommend item number 3 and 500. 3, 4, 500. On behalf of Ms. M. Soikia, as M. Soikia. Just some personal difficulty to
Yeah, for the appellant. Who is Saikia? Which N Saikia? Miss N Saikia. Who is she? Huh? No. Representing whom? Which respondent? Private respondent. She is representing private respondent in all the cases.
Yes. Oh, yes, on that.
In the review also.
Review is review. Is the
Okay. Okay. So this appeal, item 3. I know. So item 3 has to be disposed of. Now there is one issue here. Whether we can take up the review.
yes, we must do that. It's independence, you know,
Acha.
The original order that I have received, that order was put before division bench, which my client has filed, but that order was upheld
By the division bench.
and in the meanwhile, this case is also came. My lord, the regulations filed by them. Then I went to Supreme Court. Supreme Court found that there are some grounds for review. So court wanted me to put key grounds before the order.
And not only that, besides that, there is another aspect of the matter. You see, as per the circular that is applicable in the High Court, where it with matters relating to review, when there is one judge remaining who had passed the order, then that judge will sit with the Honorable Chief Justice. Now both the judges have now retired, I think. Now whether, leaving aside whether I had passed the earlier order, whether we both of us could sit without an order of the Chief Justice. Because huh? No, but the problem is I am one of the judges in those review. Huh. No, but then the problem is I am one of the judges who passed the case in the review.
Yeah, that is why I'm saying that is what I'm saying that liquidation is going to be there.
I don't know. I think they're apprehensive if I take up the matter, if we take up the matter with me sitting there. Probably, because I've already passed an order against him. You see, in the other case, so he'll be apprehensive. You just give me in which review?
You come back, it was 4 and 5 are the review.
Yes, but in which one have I passed that order?
I'm gonna take that.
Yes, please take the fact. Let us clarify this issue. So that otherwise, correct. But then it has been tagged. That is the problem.
No. There have been functions where they are apart. Reason being, my lord, when we met in before the honorable chief justice, my lord, so we made a prayer because these are our connected centers and we are relying upon.
Just give me item 4.
Yeah, we got it. No, matter what it is.
Correct. That's the administrative decision. Review petition. Where is the order? 168 here. Yes.
The order of the review is page number 44, my lord, and the order of the
Just a minute. 44 is the order passed by the division bench, dismissing the appeal filed by you, and the order passed by me is at page.
at page 48.
248.
At 246, the order starts.
246.
The order starting, the order can be read from 248.
246.
1/11/2018. For certain materials were not placed.
Anyway, so basically, the writ petition was allowed.
I was the private respondent there.
Your private respondent, you filed an appeal. That was dismissed. That was dismissed. Now, thereafter, now, what is this, the connection of this case, this review to the WA?
Now, my lord, see, we private respondent.
Yes, President.
The connection there is very simple, my lord. The NCT, when my case was decided, they did not place some material documents and put adding passing case order. Now, surprisingly, in the current appeal, the NCT themselves have taken a completely U-turn, really they are admitting the contentions that I have made for your lordship. Now, while NCT would not have placed these materials subsequently, they should have placed a correct affidavit in my case. They never placed the correct affidavit. In fact, the order under appeal observes categorically, my lord, that the NCT has failed to place correct materials.
Okay, so the result of the writ appeal will decide the fate of the review
Of my
of both the review.
that is the reason why I have been paid
The notices are issued.
that is
NCT will come up with their plea now, with the new plea, the new petitions also by the they can come. Because in these petitions by the NCT came up with a plea.
So so do we detach this review?
basically can always do that.
Petitions followed by.
Because otherwise I cannot take up if it's not detached. No, if he doesn't want, he's having apprehensions. then-
What I'm saying, he said that against me, they also were, these petitions cannot be decided through district notice.
Has to be issued, notice has to be
I'm
issued.
not arguing on that.
But I cannot issue notice in the review because I am the counsel, I am the judge.
Then there will have to be another bench constituted for taking up the review, then again multiple benches will be having, maybe I don't know, because one bench has to pass an order.
Okay, right. Okay, we'll adjourn the matter. Yeah. Because I cannot take it. Okay, right. Heard Mr. H. Buragohain for the review petitioner in review petition 168/2019, and that's all.
And she appearing for S.
No, before that, you're in 168 only. 168. Then who is for in WA? Mr. I.H. Shaikya appears for the writ appellant in WA number 154/2022. Who is the review petitioner in 136? Ms. N. Shaikya, senior counsel, is the petitioner in review petition number 136/2022. The counsels for the parties submit that the decision that will be taken in connection with WA number 154/2022 will have a bearing on review petition number 168/2019 and 136/2022. Next paragraph. On perusal of the records of review petition number 168/2019, it is seen that the judgment and order dated 1/11/2018 passed in WPC. No, it is seen that way. It is seen that the it is seen that the order dated 29/4/2019 passed in WA number 354/2018 has been put to challenge by way of review. The order dated 29/4/2019 passed in WA number 354/2018 had upheld the judgment and order dated 1/11/2018 passed in WPC number 4674/2007, which is authored by one of us. When you write bracket, that's just my in view of the above, the matter may be listed before some other bench. Come up with
and there is a review petitions where notice needs to be issued. Whether notice is issued, whether they are executed or not, this needs to be decided. The appeal that we decided in the meantime they will.
no, but then would it be proper for me to decide whether it should be decided? I think better not. Let it be decided by the what have I said?
Listed before some other bench.
Let it be listed before some other bench and not before one of us. Then you write bracket my name. Huh? This one. Next paragraph. With regard to the prayer made by Mr. I.H. Shaikya, learned counsel for the appellant in WA number 154/2022, which is to the effect that the two review petitions which has been tagged along with this appeal should be detached from the appeal, we are of the view that the said decision, we are of the view that a decision with regard to the above can be taken by a subsequent bench. Better. Otherwise, I don't. No, let the registry bring to the notice of the Chief Justice the order passed today.
And that I'm appealing on the, in case number 293 on the above response number.
Okay, then you write that, then at the beginning, huh? Miss K. Devi appears for
Response number 8.
response number 8
In
in,
WPC number 293.
there is no WPC, madam, in WA number 154/2022.
And he-
Mr. S.K. Goswami appears for point number 7 in WA number 154/2022.
I am for NCT law. And it will be
Mr. N.H. Borbia appears for the appears for the NCT in WA number 154/2022. No notice has been issued in the review. Anybody else? Then you, huh? Yes, let it go to the Chief Justice. I cannot do it. Just write one thing. Mr. I.H. Shaikhi also submits that no notice has been issued in the review petitions, and as such, the same should be detached from the writ appeal. We have said that the registry will bring it to the notice of the Chief Justice. You see, unless a special bench is constituted by the Chief Justice, supposing we direct that it should be listed, before whom will it be listed? It is not so simple. It will be brought before his, it will be brought to his notice. Let him decide. And there's another aspect of the matter, whether the review would have to be heard by the Chief Justice or not. That is also another aspect which maybe we should incorporate here. Doesn't matter. Just out of abundant caution. It's not that I'm running away from it. Only thing is that I don't want them to say, you see, they are apprehensive because already I passed an order against them as a single judge. So when I pass an order in the writ appeal, they say, supposing I pass an order against them again, they say, expected, you have done this, you are also. So only because of that, nothing else. If he's agreeable, we are ready to pass, we are ready to decide, but he's not agreeable.
One, there is a witness number 5193 of 2018 and another content case number 499 of 2021. So should the kindly give it?
That is a division bench matter.
No, no.
Then the single bench. What does it look like? Single bench.
Item 1.
Lordship in the instant case, to one, you find an objection. Lordship, somehow it's not a record matter. No, maybe we have 29,000.
With regard in the IA.
Lordship, my colleague has verified.
I check the IA.
So what to do? When did you file the objection?
My record says on 29,022. They received on
on
29, 2020,
29/20.
209, 202.
And when did you file?
Lordship, they have received the total.
Okay.
That is our office.
No, there's a thing called receipt and there's a thing called non-filing also.
Yes,
That is the question mark,
yes.
whether you
Lordship,
really
let the
filed.
Office verify the same matter.
No, unless you
Lordship,
verify.
because we, after being the date, we will give it to our clerk, Lordship.
Then you verify with your clerk whether he filed it or not. There'll be a filing
Yes,
number.
yes.
There'll be a filing number. Can't ask the registry to do everything. Then what to do? And what about the records have arrived? Paper book is necessary or not? Paper book is necessary. Okay, they're right in the IA. Yes, Mrs. B. Boyan, learned additional PP, submits that objection to the IA for suspension of the sentence had been given to the appellant's counsel on 20/09/22. So, however, the same is not on record. Ms. B. Buyan, additional PP, shall verify as to whether the same has been filed in the registry. So, if the same has been filed in the registry, the same should be placed on record. List the matter on after a week. When? '28. On 20. List the matter on 20. 202, huh? Then in the main case, you write Mr. U. Chaudhary, Mr. B. M. Chaudhary appears for the petitioner, appellant, while Ms. So appears for additional PP appears for the state. The LCR has been received by the registry. Accordingly, registry to prepare the paper book. And this is the matter. After preparation of the paper.
I will be.
I will be coming on that.
Yes.
Item 6.
Okay, you write list the matter on same date. Otherwise, it will be a problem. List the matter on 20th. Huh? Mr. B. Prasad. But that is the only matter we have got left. There's nothing else. After there is a single bench. Okay, right. On the pair of the parties, the matter is adjourned for 2 weeks. This is the matter after 2. No matter. Unfortunately, no matter. Everything has been adjourned. Huh? We don't have any. Acha, we have got. No, we have got. Sorry. No, this is single. Okay. I don't have that.
Party list.
Oh, part 2 list is there. I didn't know. I haven't been given the list.
There is a list. Special division list.
Files are not available. What is this? Why files are not available?
I know. So there.
Did you see it? Did you see it? What is happening?
this was earlier attached with Justice Water.
Okay, that list was attached with one. Okay, it has been shifted to our bench. No, this is the part one. Where is the hearing? Here is the hearing. Okay, okay. Division bench two. We have not been given any files. Well, yes, naturally, there's nothing else, no other option when there's no files there. Please look at it. Yes,
Mention item number 26.
just a minute, madam. 26. I think 26 is not before this court. It is before Justice Surana. Because there is a notification issued. Just show us the notice. Thirty. Item 30. There is one item 30. Where is the item? Yes, show. First, give me the file. Okay, item 30. When?
Around 20.
20. 20 is a, okay, right, on the prayer made by Mr.
GP.
You are going to appear now. Mr. G. Pegu, CGC.
No.
Item 30.
Item
13.
13. 1-3. Oh, 1-3.
Yeah, Sona Circle. Sona Circle.
No, item 13, I think before me.
Oh, yeah.
Item 13, right. On the prayer made by Mr. G. Pegu for adjournment. Who submits that he has taken the consent of the petitioner's counsel, Mr. M.U. Mahmood. This is the matter on 20.
Item 29.
Mr. Who is appearing?
MK Chaudhary.
M.K. Chaudhary. He'll be appearing for Indian Oil. Oil India. Where is the petitioner's counsel?
I assume the lordship may probably have not, I don't know, your lordship, I haven't seen the petitioner yet. But I'm making this prayer on behalf of my other lordship.
Today, we're going to have no work today.
There's the entire list was taken up.
Ah.
So that
Entire list was not only taken off, I couldn't do those, we couldn't do those DB matters because of I having written one judgment also, which was under review.
assuming it also on legs right now.
No, it's okay. I want.
But besides that, also you need some time to very lordship next during the lordship. That's why lordship can see result. Wait for a day and wait for a lordship.
But at least the petitioner's counsel should have been informed.
So we are waiting for the matter to actually come out with.
So it has come up.
Yes.
Ask me a second, I'll just.
Yes, just find out.
Yes.
Then 30.
Yes, what to do, Mr. I know. Yes, just let me go through. Yes. Here for the petitioner. Now they want adjournment. After tomorrow. After tomorrow, no, it's too short. It's too short. I know, but then Thursday we have already fixed one division bench matter. Right, adjournment prayer has been that item thing, item 29. Adjournment prayer has been made by Mr. M. Sharma on behalf of Mr. M. K. Chowdhury, learned senior counsel. He submits that Mr. M. K. Chowdhury has recently been engaged as standing counsel, as counsel for the Oil India Limited, and needs some time to go through the brief. Mr. S. Gautam appears on behalf of the petitioner and submits that he has got no objection to the prayer for adjournment. On the consent of the parties, list the matter on 16. Yes. So basically, let us recapitulate You are paying for area salary from 5/5/2001 to 12/12/2005, and from 2/1/2008 to 25/11/2014. Correct?
Yes.
You are appointed as cinema hall manager in the year 1984, and you were confirmed in 1997. Then your service was terminated on 23/4/2001. Correct? Then you filed a writ petition, and the writ petition was disposed of with the direction that post-retirement benefits should be paid to you, and thereafter the service of the petitioner should be terminated. May be terminated. May be terminated. Thereafter, you are reinstated into service. And while revoking the notice of termination, it was also stated that fresh orders will be issued on completion of court of inquiry procedure. Fresh orders regarding what?
The allegation was regarding financial.
The financial. Then subsequent to the above, you filed another writ petition because you were not allowed to rejoin your duty. Correct? So the writ petition was disposed of by directing that you should be paid the salary, and they were also given the liberty to complete the inquiry proceedings against you. Then you were reinstated into service
8/12/2005.
with immediate effect. So why are you asking for payment of area from 5/5/2001?
5/5. Okay. From 5/5/2001, my salary was complete.
From 5/5 then. Because the order of this, the order passed by the court was on 1/5/2001. Correct? So you were paid salary till 5/5. Are you sure?
So my from 5/5/2001 to 12/12/2005.
So then you were reinstated. No, then so you were reinstated. Then
Reinstatement order is a case 37.
no, order dated
8/12/2005.
8/2005. Where?
Case 37 of 5.
Page 37. Page 37.
From 2005, I was in service. Then on 2/1/2008, my service was terminated. Following the department.
Just a minute. Just a minute. Yes, so you were reinstated into service. So from but you were not paid from two 1/2008, is it?
2/1/2008, my service was terminated.
Okay. 2/1/2008. Okay, the service of term. Then you file the writ petition.
Then I filed the petition, the petition number 4182/2008,
Huh.
and this observation report said that termination order. Case 45 is the abiding question.
Order dated.
Order dated 1/6/2015.
Page 45.
Case 45 is the abiding question. Paragraph 26 of the above a conclusion may be drawn that inquiry proceeding conducted against the petitioner did not comply with the requirements of their procedure. Not only that, it appears that the authority must be determined to remove the petitioner. That extent inquiry appears to be their community. Some circumstances court of the written penalty imposed on the petitioner on the basis of such inquiry report would be difficult to sustain. However, the court cannot also remain obvious of the fact that cinema hall in question has been closed down with effect from circumstances. Thus, in view of the above, the improved penalty dated 1008 is hereby set aside and passed. However, taking overall view, the matter is remanded back to the superior authority to take a fresh decision in the light of the above, in the light of the observations made above, which should also include the period of service of the petitioner from 5/5/2001 to 12/12/2005. The appropriate decision shall be taken within a period of 3 months from the date of receipt of the certificate of this order and communicated to the petitioner.
So what was the observation?
What is observation is that case paragraph 19, case 40.
Yes.
Paragraph 19.
Yes.
Moreover, it is not understood in what context the approach of the observation was made as the date as the order dated 16/8/2005 does not disclose tendency of any independent proceeding against the petitioner at that stage. It is also not clear what happened between 31/5/2001 when the earlier termination order was revoked and the petitioner was asked to join, and at 16/8/2005 when this order was passed by the court directing the respondent to allow the petitioner to join service. However, considering the fact the court had passed a fresh order on 16/8/2005 directing the respondents to allow the petitioner to join the service, it would mean that petitioner was not allowed to join the service before. Then paragraph 22. From reading of the inquiry report, it seems that presenting officer had produced 3 documents, exhibit A, L, and M, in support of charge. In addition, three more documents, B, W, and Y, were produced by the presenting officer in the course of inquiry, which were not mentioned or included in the list of documents. Not only that, the inquiry officer in the course of inquiry proceedings requisitioned as many as 6 documents for the purpose of inquiry, which also were not mentioned or included in the list of documents. The additional 3 documents were as follows. The following additional documents are required produced by the presenting officer during the progress of inquiry. Copy of letter dated 12 May 2000 for receipt of ₹25,000 from of Messrs. and copy of Indian Bank Roya letter dated 27 July 2007. Copy of the Indian Bank Roya letter dated 25 August 2007. The following documents were collected were also called by the inquiry officer during the inquiry proceedings for verification of the IO and delinquent officer. 6 documents are mentioned.
So what is the finding? Huh?
26 documents of the basis of which was terminated.
So in para 19, it has been said that to pass a fresh order on 16/8 to the so it would mean that the petitioner was not allowed to join his service before that. So it appears that you did not allow him to join his service. That's why he filed. So this is the finding of the court. So if you are not allowed to join, then why should he be denied salary for the period he was not allowed to join?
And let's show you Lordship, the case 85 years.
85.
85, last year.
Wait, 85. Yes.
We are finding that C
Yes.
brought out here. You were requested to rejoin for duty on 31st May 2001. Firstly, in view of the Honorable High Court order dated 1 May 2001, and secondly, for conducting a court of inquiry in the case irregular, and the available records indicate that you had not joined duty. Apparently, in view of the pending inquiry into alleged financial irregularities committed by you. Accordingly, since you have not performed any duty in the said venture during the period 5 May 2001 to 31st August 2008, the date of closing down of the venture, you are not eligible for any wages for the period. Further, since the venture itself was closed down on 31st August 2004, you are not eligible for any wages for the period 1st of September 2004 to 12th June 2005. So the Lordship, this suggestion for my order dated Lordship 16/1/2015 dictated to the period of service from 5/5/2001 to 12/12/2005. So they have considered that and they have said that I have not joined, I have not worked, therefore I am not accepted salary for that period.
Where have they said?
Actually, in the paragraph C,
Okay.
page 85. They have said that I have not joined, I have not worked, therefore I am not entitled. So in this regard, I want to show that on 31st May 2001, the termination order was revoked. The period is from 5/5/2001 to 12/12/2005. In between 31st 5/2001, the termination order was revoked. It's the place 28. And in between, my entry pass was expired. I applied for the renewal of the entry pass, which is the page 31. July 2001, I applied for the renewal of the entry pass. Then also they did not renew my entry pass. They did not allow me to enter into the premises. There is no alternative by department representation. It is page 32. They did not consider them. Then I filed a petition.
No, wait. Just a minute. We're off track. So then this court said also from the period from 2/1/2008 to 25/11/2014. What about this aspect? Huh? No, the court in its order,
Page 46 also.
page 46.
5/5/2001, 12/12/2005.
Not only that, the next portion, 2005. Okay.
From 2001, 2005, I did not work in the organization. We are called. I just want to show that. It was not the part of the petitioner. It is not going to be a vessel joint.
So it was only from 5/5/2001. 2005. Then what happened after that?
Then in the year 2003, I have filed a petition. And that petition was disposed of. on
2003? After the 2008 writ petition.
No, no, sir. In the 2003, I filed it.
No.
Case 36, Lord. The order is a case 36.
I know that is a different. I'm not going according to what you're saying. I'm asking you, after the 4182/2008 writ petition was disposed of, what happened? Where is the board of inquiry, additional board of inquiry?
Board of Inquiry was constituted, Lord.
Where is it? Page?
Page 84, Lord. Page 84, A. Last paragraph. You were appointed as manager of an independent non-profit fund and NPF Welfare Venture AF Cinema on 1st of February 1984, which was closed down on 31st August 2004 due to incurring of heavy losses. Conduct of a board of inquiry at this belated stage concerning the irregularities committed prior to the period 2001 is considered as impracticable in view of long passage of time, and also considering that none of the punishment mentioned in Rule 19 of BACL 29/1999 can be validly awarded at this belated stage after closing down of the venture itself in the year 2004. Accordingly, it has been decided to dispense with the conduct of any board of inquiry into the said irregularities at this belated stage. As per order of this honorable court, is passed on to the.
What is this impugns the speaking order?
Yes,
Speaking order 2019, where is this? Okay, that is it.
it starts at page 80. This honorable court directed in the year 2015 to dispose of, to decide the departmental proceeding and other claim within 3 months. But they have decided it in the year 2019. And in the
Just a minute. So you continued to work, huh? You see, our WPC 4182/2008 was disposed of on 1/6/2015. But this is WPC 4182/2008 is with regard to your removal from service. Correct. And that was disposed of on 1/6/2015. So why should you get anything for that period you are not working?
They have set aside that order. This honorable court set aside that order. And when this honorable court directed them.
So if they set aside an order, so should you get payment? Where is the judgment that you should get? No, they show me that. First of all. They show me a judgment which says that if you are found, if you are acquitted, or if it has been set aside by the court. No pay, so you were not working.
As soon as the termination order is set aside, termination order is that 1/8/2008 is set aside, I become the regular employee. And
No, you see, it was set aside by order dated 2015, but you retired in 2014. Your date of retirement 2014. Correct. Now, I want a judgment which says that if you are termination is set aside, then you should get wages for the period that you was terminated.
My uncle,
Is there any judgment?
yeah, my conviction is that lordship, here how I could not serve lordship. And therefore they did not say that you did not work for that period, and therefore you are not entitled for salary for that period. And as soon as the termination order is set aside, lordship, I became a regular. In fact, lordship, when the dishonorable court in the 2015 directed them to decide the matter at base, lordship, they have blocked the department procedure. They did not find the people. And for 2001, 2005,
No, I understand. Only problem is, I think there is a judgment which says that if your termination is found to be wrong, be done, then you can get any judgment you don't have.
that time,
Because you did not work for that period, for the period you were terminated. That is clear. So we have to see that aspect.
I have regarding so regarding lordship, no principle of no work this matter lordship, she was released from service prior to her retirement lordship. 1 year retirement. This already report held that since that institution was allowed lordship by the honorable division bench lordship.
That's a different issue. Yes, madam. What is your case?
The cinema hall where he was working, there was closed down in the year 2004. In the judgment also, honorable court has said that it should be taken note that cinema hall had already been closed also. This is the cinema hall manager have to pay from the earning of the cinema hall lodging. But only to honoring the order of this honorable court, the authorities have already been some
If
other
you
details.
see, once it has been closed down in 2004,
Yes.
you have, though it was closed down in 2004, you have issued a letter in 2005 reinstating the petition into service.
That is their biggest mistake, lordship. All the
Ah.
other employees, their
Ah,
side must
so-
be that.
so- Then you have to pay.
But
If it, just because it has been closed down, why did you reinstate him into service? Okay, your argument is that to honor the order of this court. When if you're honoring it, you order it in full measure, not half measure. You don't reinstate him without any pay. How can you do that? You have to reinstate him.
then court also given the liberty to go for a fresh inquiry proceeding, lordship.
Inquiry proceeding, but then you cannot do away with the service that he has already been given by him. He has already given service. Now it cannot take back away his right that had been there earlier.
The inquiry proceeding was delayed for some reason, from our part, from some reason, he had also not approached. He had said about that that non-validity, expiry of validity of his identity card, but we are denying that lordship, that may not be a ground to, if someone.
No, but then the court has held. The court has held in, I think, para 19 at page 42. At page 42. Page 43. Page 43 top. First, it would mean that the petitioner was not allowed to join service before. Page 43 top. So this is the finding of the court.
Lordship, then-
So once you have not allowed him, he wants to join. So then you have to pay.
Lordship, then lordship, the last para, lordship, para 27.
Para 45 days.
Thus, in view of the above, the increased penalty that so and so is hereby set aside and was, however, taking an overall view, major is remanded back to the disciplinary authority to take a fresh decision in the light of the observation.
Yes.
thereof, which should also include the period of service of the petitioner from so and so.
Correct, madam. It is the disciplinary authority who has to take a decision. However, the board of inquiry has been stopped, has been dispensed with. So where's the question of any disciplinary authority taking a decision? Disciplinary authority role is only with regard to any disciplinary inquiry, disciplinary action being taken. But when that has been dispensed with, what remains? It is for the disciplinary authority. It is only when a departmental proceeding is there that a disciplinary authority can act. Once the board of inquiry has been dispensed with regard to the financial irregularities allegedly committed by the petitioner, once that has been dispensed with, there's no role of any disciplinary authority there.
Okay, but the period to
Correct.
period of service, that
Correct.
is the
Correct. Period of service, not by the respondents, by the disciplinary authority only.
But the authority have passed the, this, speaking on the lordship, and they have specifically mentioned
How?
that this period lordship, is 85 lordship. See, as brought out herein above, you were asked to rejoin for duty on 31 May 2001 firstly, in view of order of Honorable High Court dated 1st May 2001, and secondly, for conducting of a court of inquiry in the alleged irregularities, and the available record indicate that you had not rejoined duty apparently in view of the pending inquiry to be alleged financial irregularities committed by you. Accordingly, since you had not performed any duty in the same venture during the period of 5th May 2001 to 31 August 2004, the date of closing down of the venture, you are not eligible for any wages for the same period. Further, since the venture itself was closed on 31 August 2004, you are also not eligible for any wages for the period so and so. Because lordship, this other employees were also removed lordship because of closing of the venture. So he may have been asked, but later on lordship, but that period, all other employees were also lordship.
You see, the problem is the court has asked the disciplinary authority to take a decision. Now, as per the law, as we know, what is the role of a disciplinary authority with regard to service matter of an employee? What is the role? Disciplinary authority, when does he come into the picture? Only when there is some disciplinary proceeding, departmental proceeding initiated against an employee. Now, if that departmental proceeding has been dropped, what role does he have? His decision is without any force of law, no backing. There's nothing to support his decision. Who is he to say this, when there is no departmental proceeding, when it has been dropped?
Dropped not because he was not found guilty, but because of the circumstances.
Whatever may be the reason, at the end of the day, dropped is dropped. Correct? A person who comes first in class and a person who comes second in class, doesn't matter if the person who comes second says, I came second because of this. At the end of the day, he still comes second. He's the number 2. So here also, it was dropped. For whatever reason, it might have been dropped, that discipline proceeding. But it is a dropped issue. Once there is a dropping of the departmental proceeding or the board of inquiry, what role does disciplinary authority have?
Court also observed that the venture had closed down. That should also be taken care of.
But remember that what had But with respect to that aspect, you had reinstated him in 2005 after it was closed down in 2004. Whose fault is that? And on the basis of the orders of the court, I admit that there is some overlapping of these court orders. The last court order is slightly overlapping on the orders passed by the earlier petitions. However, the fact remains that the last court order has held that the disciplinary authority can take a decision. But it has to be kept in mind that that decision to be taken is with regard to the inquiry being conducted against the petition, not a separate decision to be made in the absence of an inquiry. And after the order of the court, the inquiry has been dispensed with. Once it is dispensed with, there is no role of the disciplinary authority.
One thing, Lordship, that delay because of how which the disciplinary proceeding had to set aside, Lordship, by the authority, Lordship. There is 57, Lordship. There is an IF filed by the Union of India that the petitioner is not cooperating with the investigation and along with the disciplinary proceeding, Lordship. That is why they filed an interlocutory application.
That is all right, madam, but at the end of the day, the disciplinary authority
They are
is gone.
Lordship, and they had also asked him to join them, but two things, Lordship, that actually he had not worked for that period, and secondly, Lordship, the cancer had closed at that time, Lordship, and
May have closed, but in the end of the day, what happens? You yourself, despite the venture closing in 2004, you yourself have stated to honor the court's order. You have given him the statement in 2005. Instead of that, you could have gone to Supreme Court. You could have said, look, High Court has passed an order for reinstatement, venture closed 2004. You have not done it.
Lordship, but he had also suffered various salary from 2001 to 2004. That
Why should he be paid?
2001 to 2004, Lordship, that at that time, Lordship,
That time venture was not closed.
no, but we have in our affidavit stated that, Lordship, cinema
Venture was closed when?
it was
Date.
in the year 2004, but Lordship, there's two of my affidavit. Petitioner service among other employees was terminated with effect of 1/5/2001. 5 cinema dated so and so 2001. Although it was closed, but the termination was of 2001.
Maybe, so that was put to challenge.
1/5/2001.
That was set aside by the court.
2001 to
It
2001.
was set aside. Once it is set aside, then why should you pay?
That is set aside only, Lordship, to the extent that as agreed to by the learned counsel for both the parties, I dispose of the petition with a direction that the service of the petitioner may be terminated in terms of Rule 25 by giving 3 months notice or by paying in lieu thereof. The person sought to be terminated shall also.
Page.
It's clear here.
My affidavit.
No, where is the order that she's reading?
This order is 1/5/2001 order, Lordship. That order was not any. But that is the order, Lordship.
Let us see the order.
The order is not, because I have quoted the relevant portion in my affidavit.
In the affidavit.
This one, this is the.
Yes.
WBC 311/2001 and the Honorable High Court filed order dated 1/5/2001 disposed of the writ petition and stated that as agreed to by the learned counsel for both the parties, I dispose of this writ petition with a direction that the service of the petitioner may be terminated in terms of Rule 25 by giving 3 months notice or by paying in lieu thereof. The person sought to be terminated shall also be
So did you give him 3 months notice, or did you give him 3 months pay?
They have paid it in the order.
2009.
90 order, they have paid in by the speaking order.
And that is after he retired. That's all. Okay. Hearing from heard Mr. D. Chaudhary, learned counsel for the petition, as well as Ms. B. Sharma, learned CGC, appearing for all the respondents. Hearing concluded, judgment reserved. I'll give the judgment in the chamber. You give me a citation with regard to once the actually there is no hospital as such. There is nothing. So yes. After the termination, once a termination is set aside by the court, then what happens? Chamber. Good, I'll have time to do this. The desk cannot be seen. The camera, that's what. Up. The desk should not be seen. No. Again, up, little bit up. Yeah.
Can you hear me, brother?
Yes, can you hear me?
I can hear you, yes.
Okay. Yes. What is your case, Mr. Petitioner?
Please unmute yourself. Unmute yourself.
Lordship, I will reconnect myself. Kindly give me 1 minute, Lordship. It has got disconnected. Give me the password, link number.
Seven, 6, 1, 1, 0. 0, 6, 9. 6, 9. Sorry. 1, 2, 3, 4.
My apologies, Lordship. Lordship, I am the petitioner. And I have made a review petition. Review petition, Lordship. So I'm praying for the review of the order dated 22nd November 2017.
I think maybe Mr. Lotha should maybe mute yourself so that.
Yes, I'm asking my colleague to review.
Yes.
Lordship, I'm sorry, Lordship. My apologies.
Yes.
So, Lordship, it is a case where certain ad hoc group 4 class 4 employees, their services were terminated by the state of Nagaland on the ground that those posts were unsanctioned while they were in service at various points, but beginning since 1989. So in that case, Lordship, I have moved a review petition. There are certain issues which requires my Lord's consideration. And I am also moving for a prayer for condonation of delay because according to me, Lordship, there is a delay of 115 days. But actually, there is a delay of almost 5 years. But since the recent judgment of Honorable Supreme Court, which was passed in October 2021, where similar issue was considered in the case of the state of Punjab. So after that, Lordship, we have got the basis to invoke my Lord's review jurisdiction. So I'm counting my limitation from that judgment of the Supreme Court because that is a new development which has given rise to the cause of action. So from that, after Corona, Lordship, which ended on 29th of May, the suspension of limitation by the Supreme Court. So from there, Lordship, we filed in the September.
That
last
judgment
year.
doesn't apply to this case, Mr. Counsel. You know it very well.
That is the Ilmo Devi versus Union of India versus Ilmo Devi.
There's been a lot of judgments after
Yeah.
that.
So, Lordship, but there are other issues, Lordship. Judgment is just one.
You see, there is this judgment was passed by us on 2017.
17, Lordship. It was passed in September, 22nd November 2017.
That judgment was not interfered with by the Supreme Court in 2018.
Yes, Lordship. The state went
And you have not made any averment with regard to whether you have been given the benefit of the judgment passed by the division bench.
We have not, Lordship, we have not claimed, my clients have not accepted the salary
No, we do not know.
for the area, Lordship.
And at this stage, after 5 years, I do not know how we can allow your review. You go to the Supreme Court.
Lordship, that is one option, Lordship. But since state has concealed certain material facts, Lordship, which the state should not be doing, because on 25th October 2021, Lordship, another single bench has passed an order that in the case of allegation of forgeries, because there were two sets of allegations, Lordship. One was that the posts were not sanctioned. And second was that some of these employees, not my client, not the review petitioner before my lords, but some other employees, they have fabricated the appointment letters altogether, and based on their services were terminated. So the learned single judge of this Honorable High Court has held that you have to prove the forgery. You can't just assume forgery. So those employees are continuing in service, Lordship. So while the Lordship,
Those
Lordship.
are different facts.
Lordship, I'm saying that the employees against whom allegation of forgery was pressed, they are continuing in service because they have not followed any procedure to prove the forgery, which is a very fair judgment, Lordship. It's a very, very fair judgment because mere allegation will not. So here I am setting up a premise for my Lord's consideration that the whole allegation that posts were not sanctioned is factually incorrect. The Honorable Supreme Court has coined the terminology of deemed and implied sanction, Lordship. It's a much older in service law. It is applicable. I can file a paper book of judgments for my Lord's consideration.
No, you can. But at this stage, I do not think that we
Lordship, I should be heard on merits, Lordship. That is my prayer.
You have been heard straight away when you have played for.
Lordship.
You have played for condonation of delay.
Yes, Lordship. That is the basic requirement, Lordship.
112 days.
Yes, it is actually 115 days.
How do you calculate this 112 days?
Yes, Lordship, I have started from the date of judgment of the Honorable Supreme Court in the case of Ilmo Devi, Union of India versus Ilmo Devi.
What is that? What is that citation?
Ilmo Devi, yes, Lordship. Yes, Lordship. My Lords. Lordship, it is. Lordship, it is Union of India and others versus Ilmo Devi and another civil appeal number. It is on page 15, Lordship, para 14 of my review petition, Lordship. If my Lords can have it.
Page 15 of your review petition.
Review petition, Lordship, yes.
1-5.
1-5, Lordship.
I'm sorry, 1-5 is not is part of the review.
Lordship, review petition 1-5. Look.
I've got the review in front of me.
Is it reported? Is it reported, Mr. Counsel?
Lordship, it is reportable, but I'm not very sure. It was declared to be reportable by the Honorable Supreme Court.
No, the case number, name of parties available. We are asking about the
CA number is also available, Lordship, civil appeal number.
correct. If it's reported, we can appreciate that from the journal. So let us.
I will dig out, Lordship. My colleague tried to search, but so that's why we gave the date of judgment and civil appeal number. But I will find out citation. Lordship.
Mr. Counsel, your page
Lordship.
15.
Yes, Lordship.
Your page 15 is a part of the review. It
Lordship.
is still the averments made in your review petition. It
Yes,
is
Lord.
not an annexure. So where is the judgment that you are talking of? You said page 15. Page 15 is still part of your review
Part of my
petition.
pleadings, Lordship. Part
Yes,
of my pleadings.
pleading. Yes.
Yes, Lordship. So I'm saying, Lordship, can I request for one small indulgence if my Lord permits? I will. My colleague has asked me for pray for my lords. Should I file a judgment complete paper book? That will be much better for my lord's consideration.
Look, we are not here to. You are supposed. This is a review.
I
Filed after 5 years.
Yeah,
After
yes,
5
Lordship.
years,
Yes,
and
Lordship.
after the Supreme Court has
Lordship.
not interfered with the judgment of the division bench.
State
Now-
SLP, Lordship, not my SLP. Lordship.
Whatever, whoever it may be,
Yes,
whoever
Lord.
it may be.
Yes, Lordship.
Now you have filed a review. You
Yes,
have
Lord.
filed an incomplete review. Why
Yes,
should we accept an incomplete review? The very basis
Dear
for
Lordship.
you asking condonation of delay
Lordship.
is not a part of your pleadings, is not a part of your petition. So why should we allow this?
No, I moved IA for conditional delay separately, Lordship. There is an
Yes,
IA.
but the basis for asking 112 days condonation is the judgment of the apex court, which you have not even brought to the brought as a part of the pleadings.
Lordship, I
And you don't
apologize.
even know.
I apologize for the inconvenience which I have caused to my lords. I'm extremely, actually, we were thinking that it will come before a physical bench. So he has prepared a complete set, but it could not be filed. We tried to file it yesterday, Lordship, yesterday. I was in Guwahati myself. I asked him to file it so that my lords are not inconvenienced. He could not file it, Lordship. I'm extremely sorry. Lordship, for this, if these are poor people, they should not be made to suffer.
They're
For my
not-
mistake, Lordship.
You see, that is not a question of being poor or not poor.
Lordship.
When you were ready to come by physically to this court,
Lordship.
and we have allowed you to plead virtually.
Lordship.
What is the question of? Is it just a question
Actually,
of
it
citation?
could not be filed. I was
You
told
cannot-
that, Lordship, please. Lordship, I was told that in Guwahati High Court, the system is to file, give it to the registry, and they in turn place it. Here in Delhi High Court, Lordship, where I'm regularly practicing, we give it generally by hand to the court, and judges normally considers. So I asked him to file it yesterday. I was there for another case, Lordship, in another case before the CBI court. So, Lordship, it could not be. I'm extremely sorry, Lordship. One more chance can be given, Lordship, to me. I will complete everything, Lordship.
You see, the question of condonation of delay on the basis of a Supreme Court judgment does not arise.
Lordship.
The condonation of delay would have to be considered from the date when the judgment was passed, not
Lordship.
from a subsequent. Now, if the Supreme Court passes a judgment
Lordship.
with regard to condonation of delay after 30 years, do you
Lordship.
mean to say that the limitation period would have to be counted from after the 30 years? I don't
Lordship.
think so.
No,
Yeah,
Lordship,
right.
it is not this way. Lordship, kindly permit me, Lordship. I have grasped the, the mind of my lords. Lordship, what I am saying is, the Order 47 says, CPC, sir, Lordship, under which review jurisdiction is exercised by my lords, it says that if a new fact comes to the notice of the petitioner which has a bearing. So I am saying the judgment of the Supreme Court where similar issues were considered. Of course, it is my fault that I should have placed the judgment.
What
before
is the new fact? What is the new fact?
New fact, Lordship.
What is the new fact?
Yes, new fact is, Lordship, that where the Supreme Court said it distinguished, in fact, Uma Devi, Lordship. You
Okay,
know,
forget. Let us say
Lordship.
that there is a new fact. What is the new fact that you
the
rely on?
new fact is, Lordship, that Honorable Supreme Court said that those who were
No,
working,
not the Supreme Court said. In this case,
Lordship.
in this review, what is the new fact that
Lordship.
we should have considered?
Yes, Lordship, that is what I'm saying. In Ilmo Devi, Lordship, Supreme Court said that valuable rights have arisen, and those rights, those who have completed 10 years of service or more, they will not be removed, and others will be removed less than 10 years. So in my case, Lordship, I'm only pleading for those who have already worked for more than 10 years. Just
Give me the
claiming
judgment.
parity with the...
Just give me the judgment. What is the number you have said?
Yes, Lordship. Yes, Lordship. So this is, Lordship, it is Union of India and others versus Ilmo Devi and another. Ilmo, Lordship, ILMO, Devi, DEVI. and another. It is, Lordship, civil appeal number
Yes.
5689 and 5690,
Of
2021, Lordship. Judgment dated 7/10/2021. Lordship, in para 23 of the judgment, their Lordship of Supreme Court have upheld the directions of the Honorable Punjab High Court that those who have completed certain years of service, they should be retained even if because they have earned some valuable rights, my lords. That is what I want my lords to consider.
So that is not a question of fact.
That's a question of fact, Lordship, certainly. But unless I come before my lords, I can't prove the question of fact, Lordship, because I will have to prove that I have completed certain years of service. So subject to that, Lordship, those who can prove, at least their cases should be considered, Lordship.
Just print it out.
Lordship?
No.
Acha, Lordship is asking the registry. I'm sincerely apologize, Lordship. I'm putting court to inconvenience. Actually, he tried to file it yesterday. Mr. Lotha tried to file, but somehow he could not succeed.
So your case is that as per section, as per para 23,
Lordship,
those persons who have worked for 10 years,
Lordship, certain period, Lordship. I mean, minimum they have mentioned in the Supreme Court.
they should be
Retained,
allowed to
they should be
continue.
retained.
They
Yes,
should be retained
yes, Lordship.
without considering the fact that whether it's a sanctioned post or not.
No, it is not exactly sanctioned post controversy, but they are not regular appointments. So because of certain irregularity in the appointments, they were removed. The Supreme Court made an exception that those who have completed, put in the service for minimum years, they should be considered.
What about Uma Devi's case? And,
Yes, Lordship.
Then
But
what about Uma Devi?
Uma Devi's earlier judgment, Lordship, this is the later
Correct.
judgment. So this distinguishes Uma Devi to that extent.
And Uma Devi is a constitution bench judgment of 2006.
Yes, Lordship, but they have considered Uma Devi in this, and then they have given this direction, Lordship. So Article 141 is available to me, Lordship. Lordship, actually, this SLP of a state that were dismissed simpliciter, Lordship. So review jurisdiction is protected. My lords, review jurisdiction is protected. Now, of course, on merits, whether I deserve or not, that's a different issue. But jurisdiction of my lords is available,
So your case is that
Lordship.
in terms of para 23 of the judgment of the apex court in Union of India versus Ilmo Devi and another,
Lordship.
the wherein it has been held that those persons who have worked for 10 years or more, they should be retained in service.
Lordship.
The period of limitation would have to be counted from the date that the decision was passed in Ilmo Devi.
That is what I'm proposing, Lordship. Of course, my lords can.
That is what you're proposing.
Otherwise, Lordship, it is 5 years. That's why in the beginning I said it is actually 5 years because my Lord's judgment was of 2017. In fact, it's 4 years, 10 months now. We filed in September 2022. I told Mr. Lotha that we have a very difficult case because of this so much of delay. But because of Corona in between everything, these people are living in remote parts of Nagaland. So they approached Mr. Lotha only sometimes in June 2021. When he started collecting information and all that, then he came to me in 2022. So that's why I could ask him to file a review so that I can bring the things to my Lord's issue. And then we filed in September, Lordship. Then it was pending because the bench was not available. My Lords have very kindly, agreed to hear us. So,
Are you a senior counsel?
Lordship, I'm not a declared senior, Lordship.
If you are not a designated senior, how are you appearing in this case in the first place?
Mr. Lotha has asked me, Lordship. So
Mr. Lotha might have asked 1,000 people, but then I think now, unless you have filed the Wakalat Nama, how can you appear in the first instance?
No, my Wakalat Nama is also with the file, Lordship. I mean, both. My name is there in the Wakalat Nama, Lordship.
Have you signed it?
Yeah, I signed it. Yeah. He said he took my signature, Lordship. This is the last page, Lordship. Obliged, Lordship.
Sanjay Kumar Srivastava.
Yes, Lordship. Lordship, actually, I was in government service. After leaving the government service, I have started practicing advocate. So I have not put in much period of service, duration of service, though I was concerned with implementation of law. So that's why I'm not a declared senior Lordship. I'm like any other counsel.
Where is the?
Actually, Lordship, it would have much better had I got the option to address the court physically, because then probably I would have carried all these judgments with me.
Where are the judgment? Where is the judgment?
Lordship, if I'm given one opportunity, I will file complete paper book, Lordship. All the judgment which I have referred, complete set, so that my lords have no inconvenience. If I'm given just one opportunity. Because I'm referring to 7-8 other judgments in support of my submissions before my lords.
With regard to what?
With regard to availability of jurisdiction, other issues, because
No, how can we? Do you know the limit of filing a review petition? I think you're well aware.
Lordship,
You
there
got a very limited field.
Yes, Lordship, that I bow down to my lords. But the recent judgment, Lordship, of 15 December 2022, Honorable Supreme Court.
That is not a question of fact. That is a question of the law laid down.
Yes, Lordship, law.
It's an authority only for what it decides.
Yes, Lordship. No, but in the case of the state of Bihar versus Kameshwar Singh, Honorable Supreme Court has laid down very elaborate criteria on which delay can be condoned. And in a recent judgment, Lordship, 15 December 2022, Noida versus Somveer Singh, the Honorable Supreme Court has upheld the.
No. Okay. Also on the merits of the case,
Lordship.
What you are trying to say is this para 23 is your submission.
That is regarding Lordship condonation, not regarding merits. Merit is different.
Okay, what is on the merits of the case? What is your case?
Yes, Lordship. On merit, my respectful submission is that the posts, it is incorrect, factually incorrect to say before the court that posts were not sanctioned. That is the whole problem has arisen. That is number one. Number two, one error has crept into. In fact, my colleague checked with the learned senior counsel who was appearing. He was also not sure how it has brought in. In fact, Lordship, an observation has been noted by the court that the petitioners are not pressing the challenge to the termination. They are only seeking the salaries. So petitioners told Mr. Lotha that they never gave any such instruction. He checked with learned senior counsel also. He said that you better inform the court if you are going for review, that this probably requires reconsideration. So, Lordship, subject to that.
Okay. Now, supposing you say that these are sanctioned posts.
Yes,
show us in your pleadings that these are sanctioned posts to which they were appointed.
Yes, Lord. Yes, Lordship. Yes, Lordship. Lordship, in the grounds, one after another, if I can take my lords to the ground, on page 17, Lordship. That ground E and 1, 2, 3 onwards. Page 17, have Lordship.
Ground E.
Ground E and subpara 1, 2, 3. There I have given that how this post was sanctioned post.
No, you show us with documents. We cannot, this is not an appeal. We cannot partake of your averments.
Lordship.
And
So-
you have got to show that there is an error apparent on the face of the record.
Yes, Lordship. Yes, Lordship. Lordship, I am relying on, regarding this sanction, Lordship, I am relying on Article 166 of the Constitution, where it says that the governor is the head of Lordship.
You cannot go into those issues here. That is not a.
May I explain, Lordship, if my lords can give me 1 minute? Lordship, these people were given a proper appointment. Service books were opened. The GPF accounts were opened. Their salaries were debited to the state exchequer. That was part of the OE, that is office expenditure of the concerned department, that Ministry of Health.
Which para are you talking about? Let us see which para. Yes, which para are you talking about?
Lordship, I was referring to ground E on page 16 onwards, Lordship.
Ground B.
E for elephant, Lordship.
Yes.
So the first I have said what is meant by doctrine of deemed and implied sanction, which Honorable Apex Court has let down, and I have referred to one judgment. That is the ground EE1, in fact, Lordship. And then I'm referring, Lordship, number 2. This is Nagaland Rules of Executive Business 2016, which is framed by the state of Nagaland for the running of the business of the various departments, and the Nagaland Fiscal Responsibility and Budget Management Act 2005, by which the expenditure, entire revenue is managed by the state. So in these two, Lordship, I am saying that unless post is sanctioned, nothing can be withdrawn. They are not permitted to withdraw a single paisa from the state exchequer in terms of Article 266 of the Constitution, unless there is a sanction of the competent authority. So I am saying that once the pay is allowed to be withdrawn, there is a deemed sanction, or pay cannot be withdrawn. Otherwise, it will become embezzlement of the government money, Lordship. So since irregularly pay has been withdrawn, there is a deemed, because everything has become part of the budget, and budget has gone to the legislature, and legislature has approved the Legislative Assembly of the Nagaland state of Nagaland. They have been approving year after year. So the sanction is very much there. There may be other issues, but to say blanket that there is no sanction per se, this is factually incorrect. Otherwise, you would not have been able to withdraw the money. The money has been withdrawn, paid, even GPF contributions have been deducted. GPF contribution have been deposited in GPF account. So all those elaborate things taking place and nobody noticing that this is happening, this can't be. Even if it has not been noticed, it becomes a deemed sanction, Lordship. So post becomes sanction, Lordship. Subsequently, and whole thing is nullified, Lordship. Lordship.
There is deemed sanction according to you.
Lordship, of the posts.
There is malafide.
Yes, Lordship, because those posts which we have got met to vacate, they have been refilled up by similarly placed persons again. So basically, it was to create slots to bring in preferred persons that we have been ousted. We have enclosed one such appointment for my Lord's consideration. So I'm saying it is whole thing becomes nullified also.
Filled up by whom?
By the same authorities, I mean, the Department of Health. That
Who is the person who has filled up the post?
Chief Medical Officer Vokha. Vokha is
No,
a district.
no. Who is the person who has been appointed?
Yes, Lordship, page 99, Lordship, of my petition. This is page 99, Lordship. May I read? Order. In the interest of public service, Shri R. Jeremo Lotha is hereby temporarily appointed to the post of lab assistant in the pay scale of so and so, so and so.
This is prior to the order pass. Our order was passed in, yes. This issues was there already.
No, Lordship, but we were
These issues
already
are already
terminated,
there.
Lordship. We were terminated. We were terminated in 2014 and 15, Lordship.
Maybe they would have been terminated also, we do not know.
Lordship, under instruction, Mr. Lotha instructs me to say that they are continuing in service. So, Mr. Lotha tells me to submit that more than 20 such persons have been re-employed and they are continuing in service, Lordship. And he says our statement can be recorded, Lordship. That is one part, Lordship. My main submission is that post had the deemed sanction because the expenditure on the payment of salary, etc., was approved by the Legislative Assembly of the state of Nagaland, who is the ultimate custodian of the expenditure and revenue. And once it passed through the concerned minister who acts on behalf of the governor, an entire administration runs in the name of governor under Article 166. So once the governor presents something before the assembly and assembly approves, then it becomes a case of deemed sanction. So it will not be legally correct to say that there was no sanction. The ground on which we have been removed.
Where is this para 23 that you are talking about in this Ilmo Devi? I've got the I've got the judgment before me. Which page?
You open the judgment. You open the judgment. Lordship, if I'm permitted one more opportunity to file entire judgment.
No. I've got it in front of me. It must be in front of you.
No, it is not with Mr. Lotha, Lordship. So
it is not maybe with him, but it is with you. This is not the way that you file.
Sorry, Lordship.
Or
extremely sorry.
make a pleading.
Lordship.
After 5 years, you come and you're not even prepared. You don't
Lordship.
even give the basis for your application for condonation, and when we get it on our own, you say that you don't have a copy. What kind of submission is that?
Lordship, I'm extremely sorry. Lordship, I'm sorry, it is para 23 of the Punjab and Haryana High Court order, which they have approved in para 8.9. In 8.9 of the Supreme Court judgment, Lordship.
You see, Mr. Counsel, you all had filed this review petition in September 2022.
22, yes, Lordship.
And the very fact that it has not been listed for so many months,
Lordship.
I am quite sure that you all knew that we were not being able to sit together, and that's why it has not been listed.
Yes, I know. My Lordship.
Today also we are sitting in different states.
Oh, Lordship, I'm sorry, Lordship.
Yes, so no, that is not a problem. So we have given you time
Lordship.
for a virtual sitting after a few months. Now you come to this court
Lordship.
after 5 years And on top of that, on the date of the hearing, you say that you're not prepared with the basis for your arguments. Then why are you wasting the time of this court?
Lordship, I'm extremely sorry. I'm sorry. I have no reason to. But Lordship, one opportunity I pray, and I will file complete paper book of the judgments.
No need. We have got the judgment.
Lordship.
What does para 23 say?
Para 23 is a Lordship, the Punjab and Haryana judgment. Punjab, and they said that those who have completed 20 years of daily wage service, even if it was unsanctioned, it will not be. They will not be removed from the service. They will continue in the Union of India. If there are no posts, they will be absorbed elsewhere. I mean, accommodated against some other post. And that Honorable Supreme Court has upheld Lordship. Meaning thereby continuous rendering of continuous service in a class 4 level employee over a prolonged period of time confers certain rights to continue in service, even if there is irregularity on the part of administrative authorities, which is what the principle of law is here, that there is irregularity on the part of the administrative authority.
Where is that? Where is that Punjab and Haryana judgment?
Is it the sub-para of paragraph 1, Mr. Counsel?
Lordship, it is the 8.9, para 8.9 of
No. Please come to sub-para 1.
sub-para 1, Lordship.
Yes, sub-para 1.
Lordship.
Is this the content of the paragraph 23 of the Punjab and Haryana High Court? You are mentioning about 20 years.
Yes, Lordship, 20 years, Lordship, but somewhere it was 10 years also. So, Lordship, it is para 1 says, in the present case, pursuant to the order passed by the learned tribunal and the order passed in the sub-contempt proceedings, the appellants came out with regularization policy dated so-and-so, and the policy they have said like this, that those who have worked for 10 years or more, but not under the covers of the orders of the courts and tribunals, they will be considered.
And was engaged against a sanctioned post. Remember that. Why
Lordship.
has this word sanctioned post been given? Because there were a lot of
Lordship.
persons who were engaged against non-sanctioned posts.
Yes,
This has
Lordship.
been held in ML Kesari also, 2010 judgment.
That is very clear that if post is not sanctioned, you
So-
don't get any right. That my lords have
Correct.
correctly.
So then what?
I'm not on the question of law, Lordship. I'm the question of fact, whether it can be said to be an unsanctioned post. That is what I'm arguing, Lordship.
But you're
What my
not
lords
showing
have said is I bow down because if the post is not sanctioned, I get no right.
Then
But I am saying that can they say that post was not sanctioned? That is the issue, Lordship.
you have to show us that it was not sanctioned. You have got
That's
to
what I'm
show
saying,
the,
Lordship. That's
show
what I'm
the
submitting,
post-
Lordship.
show the post creation. Show the
I'm
post
coming.
creation.
Yes, Lordship. I am saying there is a deemed and implied sanction to the post because the salary of the post were drawn from the government exchequer, and which can be drawn in terms of Article 266 only with the permission of the State Assembly. The permission has been obtained by the Honorable Minister of both Health and Finance, and the permission has been granted. Once the Honorable Minister has gone to the Assembly and taken the sanction to draw the expenditure on my pay and allowances, including GPF contribution,
Mr. Counsel, all pay and allowances
Lordship.
of these persons, of number of persons are given from the public exchequer. No authority will give from his own pocket. Let us be very clear.
Obviously, Lordship, nobody, even I will not give it from my pocket. It has to come from the state exchequer. But Lordship, the financial discipline, that's why I'm referring to these two.
Financial
these two
discipline
rules.
is a different issue.
But it is not the case of the state of Nagaland that any misappropriation or any irregularity in the drawing of the pay and allowances have been committed. So in that case, Lordship, these posts should be considered to be deemed sanctioned, Lordship. That is my humble submission,
Mr. Srivastava,
Lordship.
besides the merits, how do you overcome this 5 years of delay by saying that it's only 100 and
Yes, Lordship. In the very beginning, I submitted that it's actually 5 years of delay. Though I technically am arguing that I want to count it from the judgment of the Honorable Supreme Court.
Now, how is that possible? How can you
Lordship,
How can you go beyond your pleadings?
Lordship, I can't go beyond my pleading, Lordship. That is that I'm bound by my pleadings because I'm before a civil court. So,
No,
Lordship,
no,
but-
you are, whether you are before a civil court or the writ court, the law laid down by the apex court is that you are bound by your pleadings. You cannot go beyond your pleadings.
CPC binds me, Lordship. That's why Supreme Court has said it. My
No,
lords
no,
are.
CPC doesn't bind you. As
Yes,
in
Lordship.
a writ court, you
No,
might not have
things
to
can be
go by
liberal,
the
Lordship.
letter.
Yes, Lordship. That my lords are correct. My lords are. So, Lordship, as my lords, Justice Nelson asked me 5 years. Lordship, there is, as I said, the recent judgment of the case of Noida. The delay of 26 years was condoned by Honorable Allahabad High Court and Honorable Supreme Court, though dismissed the SLP on merits. They upheld the condonation of delay. So I'm submitting my lords have due jurisdiction to condone it if my lords are otherwise satisfied. I mean, my lords are not inhibited in want of jurisdiction in condoning delay of 5 years. That is my humble submission. My lords do have jurisdiction, of course, depending on the facts of the case, whether it is required to be done or not. That is something which will have to argue. So, if I will to make out,
provided we allow the application today.
yes, Lord, that is always there, Lordship, because it is for my lords to consider and allow. But I am saying my lords do have jurisdiction. It is not that there is no jurisdiction available with the Honorable Court. So I'm invoking the jurisdiction, but I have to make out my case on merits. I have to satisfy the court on merits that I do deserve this indulgence or consideration.
Brother Nelson, I think we have heard enough. Then we'll pass the order. I'll just have to discuss and then we'll pass an order
Lordship.
whether to allow your application for condonation or not.
That is
And
yes.
anything from the
My colleague.
we'll consider whether the notice has to be issued
Yes,
or
Lordship.
whether it should be dismissed.
It is my lord's discretion, Lordship. I submit to my lords.
He has not
My
given
lord.
a copy of
My
this petition to the government advocate or what? Is anybody there for the government?
It's been served to the government advocate. It has been
Yes,
served,
it's
Lordship.
Yes, anyone is there? Who is there? I can see one lady.
Lordship, yeah,
Lordship, I'm appearing for a stage of respondents, Lordship.
Yes, anything to submit, madam?
No, Lordship.
Not. Okay, we will, I think we will pass an order whether, and we will decide whether notice should be issued or it should
Lordship.
be dismissed. Okay.
Lordship.
It will be passed in today or
It will
tomorrow.
take time, Lordship, because my lords are sitting in 2 different places. So my
Yes,
lord,
yes.
as per convenience of the
We have got to discuss.
yes, Lordship, as per convenience of my lords, I will wait for the judgment of my lords. Lordship, if permitted, Mr. Lotha wants to address the court, my colleague, if my lords permit.
Okay, let us hear him. But you,
Yeah,
you
yes, sir.
please, you please switch off your, you please.
Yes,
make
Lordship,
yourself
yes,
mute.
Lordship.
May it so please your lordship. I am on behalf of the petitioners and I would
Please
like.
sit down. We cannot see you. Please sit down.
Yes, may it so please your lordship. I am on behalf of the petitioners and yesterday I was supposed to compile all the case judgments that in support of this writ petition, but because I haven't slept for a few days because of cough and cold and all this, my senior has instructed me to submit certain documents in the Guwahati High Court registry in which we are relying on the documents today. But because of my sickness and health and all this, I was not able to submit all the documents. And then the petitioners are all people living in, employed as fourth-grade employees. And they're all living in the village and all this, and then they are not aware of all their rights and everything also, my lord. And as per my investigation, personal investigation, there have been more than 25 and 30 plus appointments given after we have been terminated from the service, and those are our posts they are holding. So when we see them that they are holding our posts, when we see them that they are taking the posts in which we were serving earlier, then it becomes a source, a sense of injustice to us. So my petitioners have requested me, but having come from a remote northeast village area, and I also studied law, but as much as I want to present, I have not much idea. Therefore, I have come to my senior here in Delhi. And with requesting him for a very long time, he has studied his best, he has studied his level best to assist us. But because of this video conferencing and everything, we have not been able to present to you properly also, my lord. But on behalf of the petitioners, I would like to pray to kindly give us another chance, because this is our life and our livelihood, my lord. And if we are not heard properly, I feel like we are not heard properly. Like if we will be given chance to present ourselves before you not in virtual court, but through physical appearance. And this is our last chance. We are coming to the court after 5 years also, my lord. So on behalf of the petitioners, I am praying one last chance, my lord, to give us, because in it is my sincere prayer, my lord. Or maybe like the notice may be allowed, and kindly give us time to discuss on merits also, my lord. Because you must High Court is a writ court is a court of equity, my lord. It does not usually count much on the period of limitation. It is not like a civil court that must, in my understanding, it is a court of equity. It is a court that does not in depth follow the rules of the CPC. As I have read in the books, it is on the, we call you our lords. We call you my lord, which means you are our savior. You can do something to help us. So a little bit of CPC may be relaxed, a little bit of our ignorance and our all this ignorance of law and our illiteracy, and then the way that we are living in a very remote places. And because of this service, we have got married also, we have children, and now we have started to live in the towns. But the government prejudiced us that we, in 2015, we have been removed from the service, and thereafter, a different set of employees have been put in our place. And we have been researching everywhere, and even in this district alone, under the CMO VOCA, which I am presenting, there have been more than 25 employees that have been appointed on the same basis, on the same basis, my lord, without any proper appointment, without any regular sanction posts. And then from 2015 and 16, they are continuing in our post till 2023 up till today. So we feel, and then even those people who have been appointed on forgery, they have been given they have been allowed to continue even without investigation by the government. And so they have not checked whether they are sanctioned or not sanctioned also. If they have checked, if the forgery was checked, whether it is sanctioned or not sanctioned, then there would that would have been a question, my lord. So kindly allow us to appear, allow us to present our case on merits, because this is our last and final chance in our entire lifetime, my lord. And then after appearing before you, my lords, we will be, and then depending on your wisdom, and we call you our lords, which means you will be able to save us from our poverty. Like I have said, we have got married because we have been provided this job by the government. And when we have started having kids, getting them admitted to school in the towns and all, the government removed us when we have to return back to the village again. And in the meantime, a different set of employees have been given the chance to get employed in our post. Now it is a total prejudice, my lord. So at least, my lords, as I have said, High Court is a court of equity. It does not look much on the rules of CPC. It does not follow much on the rules of the rules of other laws, my lord. So kindly permit us to at least appear our case on merits for the one last time in our entire life. And then there are some of my colleagues who have been appointed since 1989. They have been appointed since 1989. They have been surviving on this major pay of like 450 rupees for more than 20 years. Thereafter, through the policy of this, and then even in this case also, my lord, there have been more than 200 people who have been appointed similarly, but only we were being targeted by the government. We were being targeted by the government in this manner, and then the rest of the people who have political backgrounds that are still continuing in service. Most of the appointments.
Just
Yes, my lord.
Just come to page 98 of your review petition. No, Mr. Lotha, you come.
Yes, my lord. It's my. Yes, thank you.
Page 98.
Yes, my lord.
Now, these persons who have been reinstated,
Yes, my lord.
were they part of the writ petitions that were decided?
No, these are part of a different writ petition, my lord. But we have been terminated on the same day, on the same inquiry, and on the same grounds, my lord.
Where are their appointment orders? These persons at page 98,
Yes.
where is their earlier appointment orders? Where is their termination?
Termination order, it is in batch, my lord. I will. It is in batch. I will show you, my lord, please. If you permit me some time. A combined termination. Yes, it is a combined termination, and I will show you. It will start from batch 194, 194 of annexure 10, my lord.
It starts as a combined or there is page 194 onwards.
Where are their names? Where is your name?
Show those names in that small order in that termination list of terminated. So that anyone pick up any name from that small order and
My lord, as much as with due diligence, I have tried to bring everything on record, but some of the documents I cannot provide to them, my lord. So kindly permit me another chance, please, because since the order and everything are not in our hands, and then these petitioners also they have placed everything like they are not in their hands also, my lord. So kindly give us another chance. This is our last and final prayer in our whole lifetime, my lord, before you, lord. So kindly give us the chance to appear on merits at least, my lord, please. It is a humble request.
if my lord permits, we complete the paper, complete file, everything, complete the whole lordship. I'm with all humility.
Yes, my lord.
If my lords give one more opportunity.
I think my brother and I will consult each other and we'll decide whether to issue notice or not.
Lordship.
My lord, kindly, please.
Lordship. Much obliged, lordship.
We'll only we'll decide. We have not decided. So
Okay,
it might be dismissed. It might notice might
It might be that's my lord's decision, lordship. That we go down to my lord's whatever my lords decide. We only pray that my lord should consider because it concerns very lowly placed persons in the society, and they have been toiling for 20 odd years, and all of a sudden they are thrown out. Lordship, that requires consideration of my lords. But my colleague has been pleading that I also am pleading.
So, brother, we end the session.
Much obliged, lordship. Obliged.